What's up, everybody? Welcome back into the episode of The Lawyer You Know. And today we're breaking down kind of a strange hearing in Brian Kohberger's case. The state has come forward asking for more restitution. And in this hearing, they admit doing something that is very, 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 very frustrating to the victims. A lot of people ask me, did the prosecutors commit malpractice in this case? It's a question that's interesting to me. I didn't really necessarily think of it like that. I'll explain why and answer that question. And then you have the defense making arguments, representing their clients, doing the best to continue to fight for their client, even after he's pled guilty and in prison for the rest of his life. But could that be a problem? And could they be creating a problem for their client with some of the arguments that they're making? Could there be a violation of this plea agreement? And if there is, then does that open the door for potentially the death penalty to be back on the table for Brian Kohberger? It was a lot more interesting than I expected when I heard what it was about. So we're going to watch it together, break it down, answer a lot of the questions that you guys have already had about this hearing. So make sure you hit that like button. Let's get started. All right, so the two most usual suspects we're going to hear mostly from are Ann Taylor and Bill Thompson, who is the blonde with the glasses. I guess there's two of those. Bill Thompson's the one with the big Santa Claus beard, and Ann Taylor's the one right above him. And then, of course, Judge Hippler, who is going to do most of the arguing on behalf of the state today. That'll be interesting, so you'll hear that. But let's listen to them open this hearing up, discuss what it's about, and get into some of the issues that a lot of you guys had with what both lawyers are saying. I was getting questions kind of not real happy with the prosecutor or the defense attorney in this case. Let's take a listen.
On the record in State v. Kohberger, CR 012431-665, the defendant has been excused from today's proceedings. It is not present.
It's interesting that he doesn't care to be there anymore, right? Was he enjoying his 15 seconds of fame as far as, Brian Kohberger goes, but he doesn't have to be here. It does concern him, but might really concern him depending on where the judge goes with this. But
defense is represented by Ms. Massoff, Ms. Taylor, and Ms. Barlow. State is represented by Mr. Thompson. This is a time set for a hearing on the state's supplemental request for restitution. The state can argue first.
Thank you, Your Honor. The attached documentation, it doesn't appear that there's a question about the amounts. I think the question that has been raised is whether the propriety of any additional restitution being ordered at this point.
So whenever we talk about restitution in a case where there's a plea agreement, sometimes it's stipulated to, sometimes it's left open for a restitution hearing. Sometimes it's left open to like anything else they want to add. It all depends on what leverage, what you're negotiating, what you want to open up, what you think might be coming as the prosecutor or the defense. It's a contract. You can negotiate all sorts of things as far as restitution goes, depending on if both sides agree to it. So we're going to talk about what was agreed to, what was not agreed to, and can you alter that agreement after the fact?
Yesterday afternoon, we did receive a supplemental filing from the defense, and I want to respond to that just for the record before I address the merits of the restitution requests themselves. As we indicated in our response to the defense objection to the additional restitution request, at the time that we entered into the plea agreement, Ms. Jennings and I were under the impression that crime victims' compensation could be available to cover reimbursement of travel expenses. And I have to clarify that now. It is true that before trial, the families approached our office asking if there were any resources we were available to pay in advance for travel expenses or expenses related to them attending trial itself. And we looked into that, our staff looked into that, and advised them no. It was my understanding, and I'm mistaken, I realized I was mistaken at this point, but it was my understanding back in early July, late June, when we were talking about the plea agreement, that crime victims' compensation could be available to reimburse expenses like that. I now know that's not correct, and it was certainly my mistake. I will own it as far as.
So the family asked, can we get reimbursed for some of these travel expenses? He said yes, because of the victims compensation fund, and he was wrong. And this is where people are asking, did he commit malpractice? Was this legal malpractice? Do the victims' families have a cause of action against Bill Thompson because he told them this, they relied on it, they spent money? So prosecutors have immunity to a lot of things like that, and they are not the victim's lawyer, right? So even putting the prosecutorial immunity aside, they are not the victim's lawyer. They don't have a contract with the victims. They don't owe the victims the same duty of care that a lawyer would their client. You know, as much as you may hate to hear that, there's a lot of duties they have to victims and things they do have to do to victims. And in certain jurisdictions, things they have to tell victims and parts of the process that victims have to be a part of. And all of that is legitimate and real. But when it comes to legal malpractice and the duties and the privity and the relationship between attorney and client, they do not have that relationship with victims. Therefore, they're not committing legal malpractice if they tell them something that's not true or that happens to be mistaken. Mistakes happen. This is not the only case mistakes like this happen on. Nobody is really an expert on how this compensation works in these scenarios, right? There's restitution, there's the victim compensation fund, there's different ways you can get access to money, especially when you have criminal defendants. Excuse me. Especially when you have criminal defendants that are going to be in prison the rest of their life, might not have any money. Sometimes it's just like, yeah, whatever, we'll pile it on. You're probably never going to get it. Or there are different ways that you can potentially collect on this. Those conversations are had. And this really sucks. I feel terrible for the victims. This is also why you want to have your own lawyer as part of the process that can look into this for you and tell you, hey, I don't think that it is going to cover it. The prosecutor says it is. So, hey, hopefully we do get it covered, but be prepared for it not to be covered. Hopefully their lawyer can explain that to them or did explain that to them at the time. So this doesn't come as a complete shock or be a real financial burden on any of the victims or witnesses or families or anybody that showed up thinking that this was going to get reimbursed, because it is a big mistake by the prosecutors. It's going to cost the victims potentially thousands of dollars. And some of those dollars is what Bill Thompson initially asked to add on to Brian Kohberger's restitution, which again, we all know that may never get paid because he may never come into that amount of money. We're going to talk about some of the money he did come into, but you're going to hear Bill Thompson say, we're withdrawing that request, Judge, because not only were we wrong when we told the victims that, we were wrong when we filed some documents with the court asking for that money. Clearly that is outside, I guess, whatever's in the plea agreement as far as agreement on restitution. So not a great look for the prosecutor, kind of an embarrassing start to this hearing. But after this initial spiel from Bill Thompson, we're not going to hear much from him again because the court is going to jump in and argue with Ann Taylor and go head to head with Ann Taylor, basically arguing as the prosecutor here. And we'll talk about whether or not I think that was appropriate and whether or not the judge was correct in that when we get to it. But we're first going to hear Bill Thompson be like, yeah, about that, I'm going to edit it. And now we're just going to ask for more funeral expenses, which was part of the plea agreement. And, so instead of this much money, we're going to ask for this much money for different, under a different category, because we're trying to fit a square peg into a round hole. And this we feel like is a round peg. So we'll listen to some of that.
Our state of mind going into the plea agreement.
So
that being said,
go ahead.
I'm sorry.
Go ahead. I'll let you finish the point on the plea agreement, and then I have a question for you about that.
And I was just finishing that point, Your Honor. So this would be a good time.
Okay. So it's pretty well settled that plea agreements are interpreted as contracts, which they are. I think it's pretty well settled contract law that a unilateral mistake does not relieve one of its contractual obligations and restrictions.
He's like, well, since you, in fact, were a party signing on to that plea agreement, we look at plea agreements now as contracts. A unilateral mistake, which means kind of like, okay, I'll give you $1 million for this cup because I believe that this cup is worth $2 million because I think that the aluminum it's made with, that I can sell it to somebody in another state, and this is exactly what they're looking for. So I'm going to buy it for $1 million. Then I buy it, you give it to me, and they're like, oh, no, that's not the aluminum cup we wanted. And I can't be like, whoa, hold on. Go back to the original contract and say, hey, I thought these people wanted this. I didn't tell you anything about it, but I was planning on selling this cup. That's my mistake. Unilateral on one side, which is different than if both of us believe that this cup was something that it's not. That's not a unilateral mistake. So Bill Thompson being mistaken about something is on him and is his fault and will be held against him. Therefore, you can't win. You can't change the contract because you were mistaken. The other side bargained for this exchange, got what they wanted, gave you what they want, what you wanted. You can't take backsies on this, Bill Thompson. And Bill Thompson eventually agrees with that, which is why he's saying we're withdrawing that claim now because we agree it was a unilateral mistake. We were just dead wrong. So we can't even ask for it, Judge.
Restrictions. So how can I how can I order this restitution if the express terms of the plea agreement, though mistaken understanding by the state, don't allow such extra crime victims compensation fund reimbursement?
Right. And Your Honor, I recognize that, and that's what I was just getting ready to address. In response to the defense's objection, the state has modified or adjusted our position on the restitution.
Which means the defense wins that argument. The defense wins that initial argument, as bad as it may seem. And I'm sure everybody's like, Kohberger should pay every penny they ever asked for the rest of their lives. I don't necessarily disagree with that, but I think it all needs to be in the plea agreement, right? So put it all in the plea agreement, make that guy, have a mountain of debt over his head, that any dollar or penny that ever comes to him, a percentage of it or all of it, or as much as we can possibly take and give to the victims, give it to him. But you have to have some forethought. You have to have some foresight when you put together these plea agreements as to what could that be. My guess is if you were able to ask for something like this, they would have agreed to it to get the death penalty off the table. Now, maybe there are certain things you can't ask for, and I understand that exists everywhere, but not great.
Are pursuant to the plea agreement seeking restitution for the funeral-related expenses, which are the urns that are described in Exhibit 2 to our response. We are not affirmatively advocating for the travel expenses and lodging expenses of the family because we do not believe that we can legally advocate for those. At the same,
he's like, so instead we're asking for additional funeral expenses, which means there were a funeral expense that they agreed to, maybe some that were even paid, but we have additional ones, and we think under the plea agreement we can advocate for additional compensation. But we know legally we can't ask for the other stuff we initially were asking for.
same time, the families provided those to us, and we want to provide them to the court and counsel just so everybody was aware that they are there. But we are not arguing affirmatively for that because of the wording of the plea agreement itself. So what the state is actually requesting today is just additional restitution for the funeral-related expenses, which are the urns for the families.
Okay, thank you. And you can address the other issues as well.
I'm sorry, Your Honor, which other issues?
Well, the issues, if you'd like, raised in opposition to your motion, including the lack of ability to pay by a defendant and et cetera.
Yes, thank you, Your Honor. I apologize. The defendant has raised the issue of his alleged inability to pay, and we recognize that he's going to be incarcerated until he dies. But that in and of itself doesn't mean that over the course of the balance of his life, he might become, he might receive assets. And in fact, we attached a breakdown of the types of monies that he has received during his incarceration. We also noted the statute that allows the treasurer to intercept prospective monies that might be received based on any attempted publication of the story of the defendant. And
which legally he can't receive it. The judge is going to go through some ways that he can, secondarily receive it. And we'll talk about, the Son of Sam type laws, not profiting off of your crimes, but how there are ways around that and how you look at it. To me, this is kind of a judge by judge thing when they look at ability to pay, because it's all speculative. You can always, it's kind of like when we have like our defendants collectible. Well, maybe not right now they're collectible, but who knows if they're going to win the lottery or if their mom's going to come into a lot of money or whatever it may be, right? So anybody could one day have enough money. How do you look at ability to pay? And we're going to hear how this judge looks at the ability to pay. But generally speaking, Brian Kohberger, as it sits right now, doesn't have the ability to pay much, but that could change based on some things that have happened in the past, based on the notoriety of his case, and based on what they're going to discuss as far as the money that he's already gotten. So the prosecutors are like, Judge, he could have the ability to pay in the future. We'll see.
those, if received, would be something that a restitution order could be enforced against. We also note that the language of the statute and the case law interpreting the restitution statute, which is 1953-04, if I believe off the top of my head, talks about current inability to pay is not necessarily a block to the order of restitution. It's just merely a factor for the court to consider. And it is our position, given the relative youth of the defendant, the fact that he has been receiving significant monies during his incarceration already, and that there is the possibility of future monies, whether by virtue of the statute with the treasurer impounding proceeds from a story related to this, or perhaps from an inheritance from his family or others. We can't see into the future. We don't have a perfect crystal ball. The state's position is having this additional.
You could basically make certain arguments like he'd come into money from his family or he's young for like a lot of defendants. But the real kicker is he's already received money. He has notoriety. There's the chance more money comes in, and therefore his ability to pay could increase. And on a case like this, it's probably commonly looked at as one of the higher probability that he does come into more money than your general person who's in prison for the rest of their life, but still the ability to pay for you and I who are outside working in the real world. Obviously he has less of ability to pay than us.
Restitution place, which is really fairly minimal, would be appropriate, and have them available that if the defendant comes into assets, that the families would be able to try to satisfy the restitution orders from them.
Thank you. And then who's arguing for defense?
I will be, Your Honor.
All right.
Thank you. Given that the state has clarified its position that it's only seeking reimbursement for the earns, it's my understanding that that amount is $1,420 for one family, $1,587.79, and then another $167.79, which would be a total, I believe, if my math is right, of $3,075.58. My understanding of reading the Victims Compensation Code 1953-04 is that the court must still do an analysis on Mr. Kohberger's ability to pay. And as the state has addressed, we are
basically, I thought Ann Taylor was making this argument. I guess she's not. That's my bad. I just listened to it. I didn't watch it. So now I'm realizing that it's Miss Massoff that's making the argument. So I was wrong in the beginning. But so they're making this argument and they're saying, maybe not even an argument. They're like, this is what they're asking for, Judge. Here's the amount. You still have to do the analysis of the ability to pay. And then, it kind of gets squirrely as to whether or not they're arguing he shouldn't have to pay this or not, which is when the judge steps in.
Are arguing that he does not have an ability to pay. While there have been lump sums provided to you regarding some funds that he received prior to his plea agreement, what the court does not have is a breakdown of how those funds came into the inmate system for his expenses and the fact that they were primarily family. Certainly his situation pre-plea and sentencing was drastically different than it is right now in terms of money that.
Meaning there were all these people that believed in him and said, Brian Kohberger is innocent and I'm going to send him money to help. They're like, all that's gone. All of that is gone.
Is available to him, and there's nothing in the record to provide the court with anything other than what is really speculation based on the past, as opposed to something that the court might be able to rely upon about foreseeability. There's no way that Mr. Kohberger is ever going to profit from any sort of movie or book because Idaho Code 1953-01 specifically precludes that.
Well, it allows.
She's like, he's not going to make money off a book or a movie. Idaho does not allow that. And here's where the judge steps in.
That monies are swept from his account for those income to pay certain things. If those certain things, if there's no debt for those certain things, then does the money not go then to the defendant?
No. That's not, at least that's not how I've ever read the statute, but they're going to talk about it. But he's like, well, what if he doesn't owe any money and he gets money off a movie or a book deal? And then when that kind of passes, he's got another argument of how potentially Brian Kohberger could get money off of book or movie deals, which I don't blame him. We want to make sure this guy does not get rich in prison, sitting there fat and happy because of what he did to those 4 college students, right? We all want to make sure of that. So let's make sure. But I don't think that he's reading the statute right.
That is not my reading of the code. Perhaps I'm reading that statute more broadly than the court is. I understood it to be that the purpose is that someone can't then profit off of their crime pursuant to that statute. I guess I need to read it with
even
that broad
allowing
implication.
even allowing your reading of it, what's to prevent, for example, a family member from agreeing to, provide information, be a part of, et cetera, a story, movie, book, whatever, TV series.
So now he's worried about a family member signing up to do that and then giving the money to the defendant. Now, here's the issue. That can always happen. That can happen in any case. If a family member does it and they want to pay the family member, you can't, the law cannot extend out to everybody that's ever known you, right? A friend wanting to capitalize on, going to middle school with you, with the killer here, and can help write a movie or a book or whatever it is. Somebody that sat in the courtroom and wants to write a movie or a book, right? So you can't extend quite that far, and anybody could ever give anybody money that they want to, right? It's like one day somebody might want to give money to John Doe or Brian Kohberger or whoever it may be. Is that really the analysis that you should do as far as ability to pay? And from my perspective, I think it's okay because they'd be profiting off of him. That's what makes him different. Somebody could profit off of him and then give him a kickback off of that. And so he does have a better ability to pay than any other inmate in the prison, right? So I do understand the analysis. That's where I feel like the judge is leaning. We'll continue to hear him argue. By the way, people were asking, is it appropriate for the judge to jump in and do the prosecutor's job? From my perspective, this feels more like the judge trying to figure out the right thing to do than it is him arguing. So he's kind of argumentative questions to the defense, but he's like, well, what if this happens? How should I analyze this? Tell me how I should do this. Kind of like an appellate court judge, or judges often do this in hearings. Tell me from your perspective, am I allowed to do this? Am I allowed to do that? What if this happens? What if that happens? Does this affect his ability to pay? Are you even allowed to be making these arguments he's about to say? So it's instead of kind of a back and forth arguing like a lawyer would, I feel like he's more trying to get information to make sure he is doing the right thing under the law, which is what judges should do. Because the lawyers are supposed to sit back there and research all of these issues ad nauseum before showing up to court.
About the murders, about Mr. Kohberger, and that certainly wouldn't be monies they receive wouldn't be subject to the statute, and then they certainly would be free to send Mr. Kohberger money to his account. What harm is it to order the restitution, which would then sort of jump in line in terms of priority of payments over some of the other ordered payments?
He's like, what's the harm? Tell me why. Tell me what trouble I'm going to get in if I grant this and I add some to the restitution just in case he ever comes into money. And that's kind of how we all look at it, right? As the society, as prosecutors, as judges, not as defense attorneys. But it's like, what's the harm in just tacking some on? So if, God forbid, he ever gets a bunch of money, the victims can get paid first. I don't disagree with that, right? I don't disagree with that. And there's the real kicker reason why coming later.
Such that if Mr. Kohberger does receive money into his accounts from any source, that he's then...
I think we should find ways to make sure that he doesn't get money, right? Whether it's the legislature writing laws, whether it's judges using their discretion, saying, I do think he has the ability to pay in the future because he is different than the other inmates there. I think this is perfectly acceptable, personally. Feel free to let me know if you disagree in the comments.
That those monies are then put to that use. Certainly, we're not worried about Mr. Kohberger's credit rating with having debts at this point. I'm not sure what the concern would be to, given the uniqueness of this case and the potential for family members, et cetera, to earn money from it, and potentially for We've seen members of the public send money to Mr. Kohberger, is my understanding, to his books. What's the downside to ensuring that the victims are as whole as possible from this by ordering the restitution, which again would jump in line from some of the other court-ordered fines, et cetera? And if the money's there, it's there. If it's not, it's not.
Judge, I don't see that Idaho code or Idaho law asks the court to make an analysis on the downside, but whether or not there is foreseeability of payment. And all of the things that you just listed are pure speculation. There is no book or movie that's in the works by any of his family, and to say that those things are going to happen is absolutely speculative, and there's nothing to substantiate those sorts of assertions happening in the future. So
well, there's a history in the 3 years he was incarcerated of him receiving 5 figures put on his books. Doesn't that give the court some history to suggest that such contributions from whatever source may continue into the future?
5 figures. So somewhere between $10,000 and $99,000 was given to Brian Kohberger in this process. And he's like, can I look back to that? Because once again, that makes him different than the vast majority of criminal defendants doing life. 5 figures of money given to him. What is the harm of making sure the victims have access to that should it continue in the future? Why not? I agree with him. Why not? And it's clear he's trying to figure out the best way to not help Brian Kohberger, to help the victims, and to make sure he doesn't profit off of what he's done, which I think is what the law tells him to do.
as I stated earlier, Judge, that was at a different time in the case. That was at a time when, he
Like that's back when people liked him, Judge.
had not entered a plea. He was not deemed convicted of the crime. The money, a lot of that money was coming from his family to be able to have communications with their son and brother. And to speculate that those types of dollars are going to be able to happen for the next many decades is exactly that. It's pure speculation, not based on something that is foreseeable or based in something that's in fact before this court.
So I disagree that it's not foreseeable or more foreseeable for him than other defendants, like I've already said, but it is speculative, right? There's definitely a speculative element to this. So I get the argument.
Well, it just seems to me that one of the, really, obviously, even application of statute requires the court to look at what might happen into the future. And I guess, it seems to me one of the best indicators of the future is the past. And in the past, his family has, you're saying the family was the source of much of these funds, has provided him funds in order for him to communicate, et cetera. That necessity will still exist going forward. I'm not aware of his family having disowned him at this point and not wanting any contact with him. And even if they are, that doesn't mean that won't change. And you call it speculation. It seems to me that it is good evidence of what may occur in the future in light of what has occurred in the past.
Well, Judge, there is a judgment against him in the amount of $28,000, and certainly 20% of every dollar that goes into his inmate account is going to go towards paying that $28,000.
So they already are taking 20% for up to the $28,000. So if I'm the judge, I'm like, so who cares? Just tack on another couple $1,000 for the victims.
Another factor that the court actually can look at under 1953-04 subsection 7 is other factors, and those factors that other factors that the court deems appropriate, and that can be collateral resources that the families obtained over $200,000, which definitely reimburse the cost of the earns in terms of economic costs.
I also want to turn to the plea agreement, because
here's where it gets squirrely, right? Here's where the judge is about to shut it down and be like, well, you sure you even want to make this argument?
isn't a reasonable interpretation of the plea agreement that the defendant will not contest the state's seeking of restitution that is outlined in the plea agreement. Otherwise, why would it need to be in the plea agreement? It seems to me it's the plea agreement, a reasonable interpretation is the defendant is agreeing to pay restitution for those items that are identified in the plea agreement, which includes victims' compensation, which includes in this case funeral expenses. So you took advantage of the plea agreement to get the benefit of the bargain regarding the state's dropping of the death penalty. Why should you not be held to the plea agreement to pay the victims the costs of interning their children?
Judge, I believe that our
He's like, are you violating the plea agreement by even making this argument? Are you sure you want to do this? You sure you want to argue to save Brian Kohberger $3,000 of debt with the potential of just blowing up the entire plea agreement?
pleading was clear that we understood that burns fell underneath a funeral cost, but that once we have a hearing on this matter, that doesn't eliminate the court's duty under 1953-04 to do the ability to pay analysis.
She's like, sure, Judge, that might all be well and good, and that might be correct, and maybe we agreed with that. So we're not necessarily arguing that you shouldn't add this money. We're just telling you you have to do the ability to earn analysis. It's like making an argument without making the argument.
And that's why.
Well, are you in violation of the plea agreement by arguing that your client shouldn't have to pay those?
We are not in violation of the plea agreement. If there was any violation of the plea agreement that took.
Hint, hint. If the judge ever asks you something like that as a defense lawyer, say, no, we're not in violation. Hey, if he's going to ask, I'm going to give him the answer.
We are not in violation of the plea agreement. If there was any violation of the plea agreement that took place, it's the state seeking this when the other expenses, when it was clear under statute and under the Idaho Victims Compensation rules that those were not reimbursable expenses.
And she's like, their unilateral mistake was the only violation of this plea agreement, Judge. But I don't see you hammering them over that.
But they've effectively withdrawn those requests and are seeking what's outlined in the plea agreement. What's the point of the plea agreement on restitution if the defense is able to argue against the restitution called for in the plea agreement itself?
Yeah, he's like, you agreed to pay some of this stuff, and now you're arguing you shouldn't have to pay it. Is that not the point of all of this?
Judge, again, in our pleading, we objected to what the state has withdrawn as of this moment at this hearing today.
Right.
We acknowledge that the earns were funeral expenses.
Right.
But once we're in this situation of having a hearing, then this other section about whether or not he has an ability to pay is triggered. We stipulated to $28,000 in restitution within 60 days.
Right.
He met the terms of the plea agreement.
But it also says the state may seek restitution regarding funeral expenses, and they're simply identifying additional funeral expenses.
I don't know what more you want me to say about the earns other than
what's the point of the plea agreement if you're not going to be bound by it?
I agreed that it was $3,075.58.
But you say you shouldn't have to pay it.
What I said was that the court needs to do the analysis under Idaho code about his ability to pay.
Why hasn't the defendant waived his right to rely on that ability to pay by agreeing to those expenses as part of the plea agreement?
I don't know how the court can enter this order today without engaging in the analysis under Idaho code because it's required. That's the way I review the case law and the code, that once there's a hearing about restitution, then the court has to engage in the analysis on the ability to pay.
So the agreement to pay is illusory.
She's like, I'm not even arguing, Judge, anymore or at all that he shouldn't have to pay. I'm just letting you know it's your duty to, in fact, do this analysis. That's all I'm saying, Judge. That's it. That's all I'm saying.
Illusory. So the agreement to pay is illusory.
Yikes. The judge is not happy. He's like, you signed this agreement. What are we doing here? Why are we arguing about this?
No, he agreed to $28,000.
It's like, no, of course it's not illusory, Judge. Of course it's not. We're not trying to do this. Illusory, of course, means not real. It's not a fake agreement. It's like, what are we doing? The judge is not happy. He's like, should I throw the plea agreement out then? You want to throw it out? Have his admissions and see how he does with the death penalty on the table? Or do you want to add $3,000 to what he owes? Come on. It's like, are you guys really arguing with me? That's what the judge is thinking here, which is what the public thinks. The public at large is feeling what the judge is feeling. And I hope you guys feel good, right? The judge saying the stuff a lot of people are thinking about this. Like, what are you doing? This is unnecessary. You don't need to make this argument.
We've agreed
But defense lawyers go down fighting. That's what we do.
that earns fall underneath. He agreed to $28,000. We've agreed that earns fall underneath.
Does he have the ability to pay that?
No, he does not have the ability.
So
to
why
pay
did
that.
you agree to it?
Because it was a specific, we were provided with those receipts within 60 days. We were not provided with the receipt for the earns within 60 days.
He's like, so you guys did this analysis yourself on the ability to pay, and you agreed to a number that you're saying now he doesn't have the ability to pay. So what's the difference if I tack on 3,000? I'm just agreeing with you. I'm agreeing that this number by receipts, 60 days, she's going to throw out that 60-day argument here that this is like untimely, but the judge is going to ask it. And it's like, come on, I'm going to do the same thing you guys did. I'm going to grant this. I'm going to, by the way, he reserves ruling at the end, but I think if I was going to guess which way he's leaning, he's going to grant this, add this on. Instead of 28,000, it'll be 31,000. The ability to pay is the same as it was before when you guys agreed to the 28,000. I think he is perfectly within his discretion to do this. That's where I think this is going, if you had to get my guess.
60 days, we were not provided with the receipt for the earns within 60 days.
So is your objection then a timeliness objection?
We did raise a timeliness objection in our pleading. I have thought about that and whether or not I think that it is a really valid argument to say that that's completely jurisdictional. I didn't to mean that the court can't take this under the review at this point in time. I didn't read the judgment language in such a strict fashion that I felt like we could say 61 days means the court's not.
She's like, even I don't think I can make a timeliness argument. I don't think it should be strictly construed like that to where the whole plea agreement's off or there might never be another dollar added. It's like they don't even believe their own argument at this point. That's kind of the feel I'm getting.
Not going to rely on, not going to consider it at all. So it is past your 60-day deadline, but I don't know that that is completely jurisdictional in the way that you drafted your judgment.
Anything else?
No.
Thank you. Mr. Thompson, any rebuttal?
Do you think he has any rebuttal? Mr. Thompson, any rebuttal after I just made all your arguments for you? He's like, no, I'm good, Judge. Thank you. Thank you, sir. You did a great job, Judge.
No.
Thank you. Mr. Thompson, any rebuttal?
No, Your Honor. Thank you.
All right, thank you. I'll take the matter under advisement, issue an opinion in due course.
It's interesting, right? As we follow these cases from beginning to end, we get to see parts of them that are unusual or not something many people talk about or questions people have, but they never get to really see how it all works. But from my perspective, I think it's always interesting to watch these things, learn something new, talk about something new, a new part of the case, a new process, because so many cases deal with this after they end and after they're over. And so many victims are dealing with things like this and never getting restitution paid for. So I thought it was kind of cool to watch that. Appreciate you guys sending it to me and asking me all the questions that you had. But that's all we got as far as analysis goes. Hopefully you guys liked it. If you did, hit the like button. Make sure you're subscribed. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the lawyer you know.